Welcome to the second edition of Talk Studio. I'm Nancy Mae Skinner, an attorney with Fager, Amsler, Keller & Chapman, counsel to MLMIC. I have the pleasure of welcoming Senior Counsel Mark Craw to discuss the New York State 2021 legislative session. Mark's governmental affairs and legislative experience includes 10 years as the Vice President of the New York Insurance Association and 10 years of the New York State Assembly, 10 years at the New York State Minority Counsel's Office. For starters, Mark, would you describe the makeup of the legislature in 2021 and how it is different or not different from recent years?
Certainly, Nancy, and thank you very much for having me on Talk Studio. Very glad to be here.
Great.
This year, the 2021 legislature was a bit different from the 2020 legislature. As a result of the 2020 elections, even more Democrats were elected to an already Democrat majority in both houses, the Assembly and the Senate. So as a result, the legislature now has over a two-thirds the Democrats in the legislature have over a two-thirds supermajority in each house. The significance of that is that they can override the governor on any vetoes of legislation that he does. So it really gives them enhanced leverage. Even when they don't have to use the override, it creates a different dynamic where he has to really work even more with the legislature, and a veto is no longer a sure thing to be upheld and not overridden. So that goes into thinking in terms of how legislation may be acted on.
Okay. So with that Democratic supermajority, is there an effect on healthcare practitioners or medical malpractice litigation issues that are important to either?
Yes, I would say there is. It's interesting, and again, I caution there's not necessarily one party that's great on either issue. There are very good, Democrat legislators and very good Republican legislators. But I think what you do tend to see with the Democrat majority is a little more sympathy for plaintiffs and a little less receptivity to business interests and defendant interests. And in our case, that's obviously our policyholders who look to us to protect, serve, and defend them in medical malpractice actions. So it makes it a little more difficult in terms of our advocacy for our policyholders in trying to stem the tide of some truly very negatively impacting bills that are put forth by the New York State Trial Lawyers Association. They are very active in trying to expand liability, and in so doing, that obviously negatively impacts our policyholders. Other legislation we'll see impacts how MLMIC handles liability claims for our policyholders, which will have an indirect but still effect on our policyholders in terms of increased premiums because of the additional costs imposed on MLMIC as an insurer. In fact, there were 5 pieces of legislation that we saw being seriously considered that the New York State trial lawyers put forward in this 2021 legislative session, and I can briefly go through those now. The first one was a bill to expand wrongful death. That's currently in law that it provides for pecuniary monetary damages primarily for the survivors of a decedent who dies as a result of negligence. Obviously, there are wrongful death actions that involve medical malpractice. This bill would vastly expand the damages available to include non-pecuniary damages such as pain and suffering, anguish, grief, loss of consortium, etc. So that's a bill that it's estimated would negatively impact medical professional liability policyholders to the tune of about 40% increased premiums. So it's truly drastic. That's by a well-respected Milliman study. So we were combating that bill, and fortunately that bill did not advance in either house this year. But it's been a constant focus by the trial lawyers. They argue the bill is unfair to these survivors, and especially, they say, doesn't take into account children or the elderly because monetarily they're not a source of support for family members, etc. They also say that our law, New York's wrongful death statute, has been in effect since 1863, and it needs to be updated, and they point to numerous other states that have broader wrongful death causes of action that include these type of damages. What the industry, the insurance industry, and others counter is that, well, if you look at it holistically, these other states also, many of them, many, have caps on pain and suffering damages. So that at least mutes the conversation slightly, but the trial bar is still, trying hard to get that legislation, but we were successful in holding that off. In addition, there were two very harmful bills regarding bad faith. Both of those bills were also defeated. They were estimated to cost the entire insurance industry as a whole approximately $7 billion. So it's a significant impact. But fortunately, those two bills were really big, major legislation that the trial lawyers were pushing. Fortunately, did not get across the finish line this session. There were, however, three bills that I would say have a less significant impact on medical malpractice policyholders, but still do have one, and I'll go through those very briefly. The first one is a bill that involves imposing somewhat of what we call prejudgment interest. Just to back up for the audience, judgment interest, once a verdict occurs, the interest begins to accrue at the rate of 9%. And that can go through the entirety of the appeal, as you well know. So this can add up significantly. This law was put into effect in 1979 when interest rates were 18%. So it's really a relic of its time. But unfortunately, the trial lawyers very much fight against bills that would lower it to the market rate or even a reasonable 3 or 4% standard, because they recognize that helps their plaintiffs and themselves monetarily. So what this bill would do is say that if a plaintiff makes a summary judgment motion in the lower court and they're denied that motion, and then on appeal the appellate court finds that the summary judgment motion should have been granted and grant it, and then the plaintiff wins a verdict, then prejudgment interest would accrue from the date of the denial of the summary judgment motion in the lower court. So it's kind of a modified version of prejudgment interest. There's a much more harmful bill, which fortunately did not go anywhere, that would say in all personal injury actions, prejudgment interest would attach from the date of the loss or injury. And that would truly be devastating financially. That would be a very significant negative bill and impact on all our policyholders. Fortunately, we've been able to keep that bill at bay and bottled up. But this more limited version of it did pass both houses. So we will be seeking a veto on that bill as well as the next two I'll mention. The second bill is regards Comprehensive Insurance Disclosure Act is what it's called. And this bill, again, much more impacts MLMIC's operations, but ultimately would have an impact on policyholders because of the increased costs. We call them frictional costs, basically, the costs of doing our business and representing our policyholders and adjusting claims, et cetera. What this bill would do, current law requires a defense counsel to reveal the existence and contents of an insurance agreement or policy, including the limits, the coverage dates, sensible things like that, if asked by a plaintiff, and if that insurance agreement could be responsible to pay part or all, indemnify any judgment rendered against the defendant. So that's current law. We abide by that daily. It's not a problem at all. And I would note that the current law expressly excludes the insurance application from being disclosed. So now you fast forward to this bill that again passed both houses. In fact, came out 10 days before the end of session. So it was a late addition, not really thoughtfully considered, et cetera, but that does happen in Albany. Bad things happen at midnight near the end of session. So this bill would greatly expand that. It would ask for information regarding contact information for the claims adjuster at MLMIC, which to us makes no sense whatsoever. There's no need for that, and we think it needlessly interposes, between the defense counsel, who's got a duty and obligation to the policyholder, and MLMIC as an insurance company. Also, it asks for information regarding application, which again, we think, that's very bad because that has private information, personal information, and a host of other details that we think there's a very good reason why the current law does not allow that to be disclosed. So we really oppose that as well. Again, we'll be seeking a veto on that. And then the third piece of legislation regards the so-called employee hearsay exception. This is an interesting bill. Again, it very much gets into the weeds, but it could have a potentially harmful impact ultimately on policyholder premiums, which is why it's important to our policyholders. What this bill would do is the current law in New York says that an employee statement against the employer's interest in litigation can be brought in as admissible evidence under the hearsay exception, which again, already you're going against hearsay, which is an important evidentiary rule that keeps out information that is rightfully deemed not to be of sufficient credibility to be used as evidence. So this hearsay exception currently only allows the employee statement against the employer's interest to come in if the employee is expressly authorized to speak on that matter by the employer. And we think that makes great sense, partly because in our current civil justice system for medical malpractice actions, it's already very one-sided against the defendant, our policyholders. So we're seeking to at least keep that, from going even more slanted and unbalanced. And we think this bill would very much do that because it would essentially allow in any employee statement that they utter while they're working, basically, and within the scope of their employment is the language. So that is just, you can see in a hospital all the instances where a non-medical employee may say something that they picked up third hand or, other statement and utterance, and that could very well come in now when they're neither authorized to speak on it nor do they really have the knowledge. So we oppose that bill as well. So.
Right, I can see that would have huge ramifications in litigation with hospitals.
Yeah.
So with these three pieces of proposed legislation that have passed both houses, what's the next step?
So the next step is, and I would add, we're working with our medical society partners and healthcare organizations such as the Medical Society of the State of New York and our other numerous medical specialty organizations, and Haney's, the Healthcare Association of New York State, to oppose all three of these bills. We'll be preparing memorandum of opposition letters we'll send to the governor on behalf of the various entities and MLMIC. But in addition, we are offering, and I would note for our policyholders, this is, I think, would be helpful. We have a link on the Albany report that is on our website, on the MLMIC website. If you go to that on Albany report number 3 of this year, near the end of the report, there is a link to a page on MSNY's website that puts you into a grassroots letter that the policyholder can fill out. Very easy, very user-friendly, and then send it, and it goes right to the governor's office. MSNY's obviously using it for their members, and they've graciously agreed to let us, refer policyholders to that. So definitely encourage as many policyholders as possible to avail themselves of this terrific tool, and we think it will be very helpful to weigh in. It's always great to, let the elected representatives, and in this case the governor's office, know how, people really dealing with this on a daily basis, such as our policyholders, feel about this and why it's harmful legislation. So we are very excited about that. In terms of the actual process, what will happen now is the bills are in the House who first passed them. So taking a simple example, let's say the insurance disclosure bill. Let's say it was, each bill has a number. So it's Assembly Bill AB 100 in the Assembly. And then insurance disclosure bill in the Senate is SB 100. They have to be identical in each house, which was satisfied in these three bills' cases. Then AB 100, if it passes in the Assembly first, it then goes over to the Senate, and the Senate passes the same bill, SB 100, and then you have two bills, or two houses have passed the same bill. That bill in that case, since it was passed first by the Assembly, would now go back to the Assembly, and they are the House of Origination, it's known as. They then work usually with the governor's office to act on that bill. And just to give people an idea of the number of bills, in 2020, due to the COVID pandemic and everything else and all the restrictions, the legislature only passed about 414 bills, both houses. Contrast that with 2019, pre-pandemic, they passed about 900 bills. This year, they got back to the 2019 level and passed about 892 bills. So those are bills that have to go to the governor's desk before December 31st. Now, they don't usually go in a batch of 800 because the governor's council, and we know how council have to do this, have to read every bill, research it, do a lot of work. So what the governor will usually do is work with the legislative clerks in both houses. His office will work with them, and they may say, please give us these 20 bills now, because once the governor gets a bill on his desk, he has 10 days, exclusive of Sundays, to sign or veto the bill. And if he, so that starts the clock, and it's a pretty, rigorous time frame, really. So what will happen is, like I said, he'll ask for those bills. We are working, I will say, with our partners to ask if the 3 bills we're dealing with can be considered later in the year. So that's part of the normal process. So we'll see where that goes. But we're working already with our association partners and our medical provider organizations to be prepared in the event of anything.
Great.
Yep.
Great. So you've spoken about the legislative side and what we've seen in terms of proposed legislation. And then obviously this year and the year before, we also saw a lot of emergency orders.
Yes.
Starting with, ending with most recently, the governor, saying the pandemic is over, the emergency order is over. So that was exciting news for everyone.
Yep.
Life can sort of go back to normal.
Yep.
But how is it still not going to be normal for our audience? Are there some parts that are being held back for our healthcare audience?
Yes, that's a great point, Nancy. Just to refresh everyone's recollection, we're so happy that it did lift.
Yes.
That's right. In March 7th, 2020, is when Governor Cuomo enacted Executive Order 202, and that declared New York in a general state of emergency, state of public health emergency. That gave him authority to then issue numerous executive orders to basically reallocate resources, direct, and basically it suspends, modifies, or even creates new rules, laws, et cetera, dealing with public health, dealing with, as we saw, the pause order to restrict non-essential businesses from gathering and basically being at their workplace. These were all definitely necessary. Nobody, I think, realistically disputes any of that. But as a result, these measures came in fast, and they came in numerous. There were over 112, I think, altogether until recently. Now, as you mentioned, fast forward today, we have such a low COVID positivity rate. All the other metrics are so good. Vaccination's way up. That, and thanks really to the great efforts of our healthcare community and our providers, they really did yeoman's work. So as a result, the governor was able to lift the state of emergency, and I think overall that was very wise and a good decision. But everyone recognizes also that certain items such as telehealth, for Medicaid recipients especially, and some other measures that really relaxed or eased some public health measures still need to be in effect because vaccinations are still occurring, for instance, and there were executive orders regarding how to do that, how to report it, how to register, et cetera. So the Department of Health has recently begun issuing emergency regulations. They did one recently on telehealth for Medicaid recipients, and they're doing other ones for, again, the vaccination requirements and registering and reporting, because you still need those measures in effect. I think what you see is the broad state of emergency by the governor took care of the big picture items, again, pause, letting businesses operate pretty much free of those constraints, et cetera. Those areas you could let go, but some health measures and other little bits and pieces of his measures definitely need to be continued. And I think then you'll see just basically state agencies giving the rules and regulations and handling those.
Right, sure. Well, so we're also going to continue to see the the effect of the stopping, tolling, or suspending of the statute of limitations during the pandemic. So there's been commentators weighing in and courts weighing in on, was it a toll, was it a suspension? Anything new on that?
Yes, thanks. We had recently a second department decision on that. It was involving, I believe, an appeal and the time frame for being able to file notice of appeal. And the second department ruled that the governor's executive order issued around, I think, April or May of last year, he basically issued, and this gets a little confusing, he said either a toll and then he said a suspension as well in the order of any and all statute of limitations and even timeframes for filing motions, et cetera. Because as we recall, courts pretty much had to be shut down as well and other matters. So it made a great deal of sense and was very sensible. But then you get into the issue when it lifted in November of last year. Okay, was it a toll, in which case that greatly expands the amount of time that a claimant can bring a lawsuit, because basically a toll truly stops the clock from when the governor's executive order was instituting it to the end of November, and then adds on that total amount of time. I think it was 280 days or some amount, people have said, that the toll was in effect, and that's added on to the person's time frame that they had to institute the action, file the papers, in this case file an appeal, et cetera. So that is significant, obviously, because it can greatly expand those timeframes. Or was it a suspension, which just says, okay, you had 2 days left and it started. That means 2 days after November 3rd or 4th, when the executive order ended, you got to get in your papers or do whatever action was temporarily suspended. So it's quite a significant matter in litigation. And the second department, as you know, said it's a toll. So they're going for the longer time frame.
Okay, so that's the appellate authority we have for now.
Yep.
I suppose we can wait and see what the other departments do and whether or not there will be a question for the Court of Appeals on that.
Definitely.
Jury's still out, but for now, I think that's where we are.
Yep.
So thank you for that. So let's talk about immunity. Immunity was given, it was taken away. There was state immunity, there was federal immunity.
Yep.
When did it start and end?
That's a great issue as well to point out, and to go back again. That started in really early March with the initial governor's executive order. They began to quickly realize that in order to fully access and make available all the healthcare resources, they needed a great deal more nurses, a great deal more physicians, a great deal more supplies, PPE. They needed hospitals and healthcare facilities to be able to reorient and readjust staffing and resources, the whole 9 yards. And unfortunately, normal medical malpractice laws and the negligence standard can get in the way of doing, making split-second crucial decisions that really would materially impact how you're handling the COVID crisis and the epidemic. So what the governor initially did was put in one of his early executive orders. It was 202.10. He said, we are going to immunize basically a healthcare provider that is taking measures to combat the COVID-19 pandemic. So it wasn't just assessing and providing care to COVID-19 patients, but what they would do, for instance, deeming a person who may have needed a procedure or surgery, saying you don't need it, it's not of such a nature that it's an emergency if you don't receive it. As we recall, elective surgeries were suspended for a period of time. So that's just one example. And they said unless the provider acted maliciously or in truly bad faith, that decision would be immunized. And I think we would all agree that that was appropriate and proper. Then flash forward, the budget is done last year in early April, and the governor and the legislature agree to include in the budget the Emergency or Disaster Treatment Protection Act. And this is the immunity law that New York was then under. The bill also made the immunity provisions retroactive to March 7th, the start of the state of emergency, which again is just sensible. That's when the measures began to be necessary. So that measure was in place. What began to happen at the same time, and everybody will recall this, is the tragedy of the nursing homes. and truly horrible situation, often through nobody's fault, in other circumstances, but a very bad situation. Many legislators began to agitate against the immunity provisions, especially to the extent that it also immunized healthcare facilities and systems that arranged for services in light of the COVID pandemic. So they lobbied very hard, and the law was modified in early August, and it was narrowed. It basically took away the whole provision that immunized the provision of arranging for healthcare services, hence not allowing healthcare facilities to have nearly the protection they did have from the original law, and also said more narrowly that immunization of liability only applied to treatment of COVID patients, assessing and caring for them, not for assessing and caring for non-COVID patients in response to the COVID situation, i.e. our scenario of, I'm sorry, you don't have to have this procedure now. It can wait till after, the suspension of elective surgery is over, et cetera. So that occurred in August. So you kind of have this time frame of April 3rd to August 3rd, roughly, as the very broad protections of the EDTPA. Then you go from August 3rd until April, I think it was 6th of this year, when they passed the state budget. Unfortunately, they repealed the EDTPA entirely. I would note it's interesting because the EDTPA, by its own provisions, would have been repealed on the lifting of the state of emergency. So that would have occurred June 24th when Cuomo lifted it. Just an interesting note. But they chose to do it earlier. There was, again, the nursing home issue became even bigger, as we recall. There's allegations against the governor regarding it, impeachment proceedings, the whole 9 yards. So the nursing home report by Attorney General James, et cetera. So it became a very difficult political issue for the legislature, and they felt they had to repeal that measure. So they did so. The governor signed it. So that immunity is gone as of that date. But for our policyholders, there was that protection for those periods of time. Again, depending when the claim arose, you have March 7th to August as one time frame where you had very broad immunity protections, and then you had a little bit narrower but still some immunity protections from August until April of this year, 2021. In addition, Nancy, which you alluded to, is there is a federal, it's called the PrEP Act, that provides some immunity for countermeasures to be taken to combat COVID-19. So.
Yeah. It sounds like you almost need a flow chart.
Yeah, exactly.
So, what was the date that you're alleged to have committed malpractice? What was the immunity at that time? What was the state immunity? What was the federal immunity? It's not an easy question, and still so many questions from the courts about what's a covered countermeasure under the federal. I know there's a 3rd district case that's pending on that, or 3rd Circuit, and then we've got some cases in New York about what's going to be covered under the state immunity. So I guess we're gonna have to talk about that next time, Mark.
Yes, that's right.
Okay. So let's end on a positive note. Okay. The free Section 18 coverage, where are we with that now?
We worked very hard with our medical partners, our society organizations, MSNY in particular, and others, as well as Haney's and the hospital groups, to restore full funding and to remove the provision putting 50% of the premium costs on the policyholders. And fortunately, the legislature and governor agreed with that, and to both their credits, they made sure that was enacted in the final state budget. So we're very relieved and pleased to let policyholders know that that program continues as is and fully picked up by the state for another year. And we'll continue to work on that and see if any future budget developments further threaten it.
Well, that's great news.
Yeah.
A nice place to end today. I want to thank Mark for joining us today. Mark alluded to his Albany report, which is something that is published 3 times a year and keeps MLMIC policyholders abreast of all relevant legislative and regulatory changes during the year. We're fortunate to have you as a guest here today, and we look forward to having you back in January when you can tell us what to expect in the new session in 2022.
Thanks. Look forward to it, Nancy.